Hello and welcome to Thinking Competition, the podcast by CS Associados, focusing on competition, business trends and economic regulation. This is a free zone for critical thinking on the markets of today and tomorrow. We want to challenge commonplace ideas and try to connect the dots in a rapidly changing world. We want to keep on asking why. Join us on this journey.
Our guest today is Professor Eric Posner, who has been Professor of Law at the University of Chicago since 1998. He holds a degree in philosophy from Yale and went on to complete his JD at Harvard Law School. He has written extensively on a wide range of legal subjects, and in 2021, he published How Antitrust Failed Workers, a book focusing on antitrust enforcement, or lack of enforcement, in labor markets, covering topics such as non-poach agreements and wage fixing. More recently, he was counsel to the Assistant Attorney General in the Antitrust Division in the Department of Justice from 2022 to 2023. Professor Posner, Eric, thank you for joining us today. It's a pleasure to meet you to discuss antitrust issues in labor markets.
Nice to have a chance to talk to you.
Thank you. Perhaps the point from which your book springs is the fact that traditionally antitrust enforcement in labor markets has been rather exceptional. There hasn't been much in the way of case law so far, and there's a great scarcity of precedent from which to draw guidance on these issues. The scenario seems to be changing slowly. Recently, in June of this year, the European Commission took its first decision on non-poach collusion in the Delivery Hero Glovo case, in which it fined both of these delivery apps more than 300 million euros. In Portugal, in fact, our competition authority has been quite keen and rather precocious in addressing non-poach and wage-fixing issues. They have two strings of decisions already, one concerning professional football clubs and football governing bodies during the COVID-19 pandemic, and a second string of cases and decisions concerning tech consultancy firms. I suppose my first question to you would be, how has antitrust enforcement in labor markets regarding issues such as non-poach, wage fixing, etc., been moving in the US more recently? What kind of new cases have been coming through over the past 2 or 3 years, either from government investigations or from private cases in the courts?
A lot has been happening. I would date the modern phase of what I call labor antitrust in the United States to the mid-teens, around 2015, 2016. So it's actually almost 10 years now, 10 years in the United States where there's been an active kind of wave of litigation against employers for a variety of anti-competitive types of anti-competitive behavior. You could probably, maybe the starting point was the human resources guidance that was issued by the Department of Justice and the Federal Trade Commission around 2000, I think it was 2016 or 2015, where the agencies announced that they were taking seriously labor antitrust. And I think almost immediately the Justice Department began criminal investigations. And of course, criminal investigations are not publicized. They took a number of years to work their way through the system. But by the late teens, the Justice Department was bringing these criminal cases against employers, usually based on no-poach agreements. And while the initial cases were largely unsuccessful, earlier this year, the Justice Department did secure its first conviction of of an employer who had engaged in a no-poach agreement. Okay, so that's the criminal side, which is, relatively, it's important in the United States, but also there aren't that many cases because they're much more difficult to win. There have been merger cases. The most important one was a case brought by the Justice Department against two of the largest commercial publishers in the United States, Penguin Random House and Simon & Schuster. And these are published bestsellers and other, popular books. And the two companies wanted to merge. And the Justice Department challenged the merger. And what was notable about this case was that the argument focused on labor markets, not product markets. So the Justice Department did not make the argument that one would normally hear, which is that the merger would cause the prices of books to increase. Instead, the Justice Department argued that the merger would cause the compensation for authors to decline. Okay, so authors, they're not really employees, but they're workers who provide inputs in the form of manuscripts to these companies. The Justice Department prevailed in that case. The merger was blocked by a court and then abandoned. And there have been a few other merger cases where labor issues have arisen, including another very big merger between Kroger and Albertsons, which are two gigantic grocery store chains. That merger was also blocked, although it wasn't blocked based on the labor market effects. The court blocked the merger based on the expected impact of the merger on the price of groceries. But labor, the impact on the wages of grocery workers was a central issue in the case. Okay, then there's been a lot of cartel enforcement. I'm going to race through these very quickly. I don't want to spend too much time or bore your listeners, but the cartel cases have generally involved no-poach agreements and sometimes wage fixing agreements. There are some cases against very large meat processing companies in the United States, which had allegedly entered into no-poach agreements or even wage-fixing agreements relating to their slaughterhouse workers. There was a smaller case against two kind of luxury retail stores, arguing that they had entered into a no-poach agreement related to their retail workers. There's a very big case that settled recently, or is in the process of settling, involving college athletics. This goes back decades, but the basic argument of the plaintiffs was that the universities in the United States, which this might sound strange in Europe, but the universities sponsor football teams, American football and basketball teams, and they never used to pay the players because the idea was the players were getting a free education and room and board, but it was a price fixing agreement. So the universities had agreed not to pay people more than their tuition, roughly speaking. And this case appears to be likely to settle for several $billion, billion with a B. There is a case involving railroad workers. I'm involved in a case which is against employers of veterinarians. So these are companies that provide medical care to people's pets, and the allegation is that the process by which internships and residencies are awarded to recent graduates of veterinary school was fixed. And then there have been a lot of cases involving these big fast food chains like Burger King and McDonald's, arguing that in the franchise agreements, the franchisees were required to promise not to poach each other's employees. Those cases are working their way through the system. And then finally, let me just mention what we call Section 2 cases, and I think you guys call abusive dominance cases. These are very rare, but there was a very important...
Monopolization.
Pardon me?
Monopolization.
Monopolization, yes. Monopolization cases.
In the US framework, yeah.
Yes. So there's a very important case which may not be well known outside the United States. It settled very recently. This was a lawsuit brought by mixed martial arts fighters, so basically boxers, and they sued the promoter for requiring them to agree to contracts with non-competes and other restrictions, with the result that there was no competition for the fighters. And this settled for over $300 million very recently. So it was not a cartel. It was the defendant was a single company, a very famous company that allegedly had monopolized the labor market for mixed martial arts fighters. So I think
that's very interesting because it's moving into unilateral behavior by dominant entities.
Right, exactly, and the sports in the United States, sports leagues have always been vulnerable to antitrust challenges, and that's what's happening in Europe as well. Sports leagues, they're very interesting because they can be designed in two different ways. Normally, each team is owned separately. So if the teams want to control how much employees are paid, they have to enter into an agreement, and these agreements are public. So they become vulnerable to a challenge. But there's another way to set up a sports league, which is just to have a single company that owns all the teams or employs all the players, and that could give rise to a monopolization claim. And that's about it. There are some other sort of smaller cases. A lot of people are bringing new cases. I practice as well as teach, and so I spend a lot of time talking with other lawyers about potential cases to bring. I think this will continue to be a growing area of competition litigation in the United States.
Thank you. That's a very useful overview. Very interesting. There seems to be quite a lot going on your side of the pond. I wonder, as a general question, if there might not be a hidden kind of mother lode of cases, antitrust cases in labor markets concerning this kind of behavior. Antitrust attention has been focused a lot on product side markets, so on the retail side, consumer facing side of markets, because it's easy to observe changes in prices, for example. It's not so easy to observe what's going on upstairs in the purchase of inputs. So I wonder if as antitrust enforcers become more keenly aware of this kind of issues, in fact the volume of cases won't increase very significantly. One other point, Professor, I wanted to discuss with you has to do with market definition. Now, product market definition we know about. It's a staple of our lives as antitrust scholars and lawyers in my case. But labor market definition seems to be almost an occult science, a largely ignored science. Quoting from your book, a labor market comprises firms that compete by offering a particular type of job to attract workers with a particular skill sets, which normally takes place within a local geographic area defined by a wider or more narrow commute zone, commuting space. My question here would be, how should one go about defining labor markets? What kind of features are relevant to consider, and what implications might an inadequate or insufficient market definition in these cases have for antitrust claims that are based on violations in labor markets? Does this have the potential to kind of, in some cases, to result in decisions to not admit the case, basically?
Right. So this is a very important question. I think, in principle, defining a labor market should not be any more difficult than defining a product market. But as you say, we have decades of experience defining product markets. We all know how to do it. We all have intuitions about, what a product market might look like. Labor markets we don't have that long history. Economists are doing a lot of work now to try to understand how we should understand labor markets for competition law purposes. And let me say a little bit about how one can think about it. So as you mentioned, there are two dimensions to a labor market, just as for a product market: a geographic dimension, and then the occupation dimension. What exactly is the job? What is it that the employer wants the worker to do? So for the geographic aspect of it. The starting point is to look at how far people commute to work, how far they're willing to commute to work. And in product markets, the analogy is how far are consumers willing to travel to buy a particular product, right? So some people, if we're talking about groceries, they're only going to walk maybe to the neighborhood grocery store. In the United States, which has more of a car culture, maybe people will drive 5 or 10 miles to a grocery store. So we might think that a grocery store, the grocery market is defined by a few miles or a few kilometers around where people live, around a residential neighborhood. And so similarly, when we look at employment, we ask how far people are willing to commute. So in the United States, people commute pretty far. Sometimes, they'll drive for an hour each way, an hour to work and an hour back. But those will probably be white-collar workers or people with reasonably well-paying jobs. In the middle of a city, some people might commute that long. Other people, they're only willing to commute as far as the bus line will take them or a subway. And so the commuting patterns are very complicated, and it's going to depend on the type of person. Maybe an elderly person might not be willing to go as far as a young person, or if one of a couple has childcare responsibilities, that person might not be willing to commute as far as other people who don't or who aren't the primary caregiver. And the way economists approach this is really, in a way, very simple. You just take a survey. So if we're talking about a merger case, and let's say each company has a work site which are nearby each other, and they're planning to combine it into a single work site, well, then we would define the labor market as the area where people who would be willing to commute to this work site. And that might be, it could be 50 miles, it could be 1 mile, it could be walking distance. It just depends on the type of work and the type of workers. So then we turn to the definition of the occupation. And this is also very difficult, but in principle, people have different occupations. And now, so let's start with us. So we're both lawyers, right? And maybe we're both antitrust lawyers. And then there are these firms that employ antitrust lawyers. So we might think that the correct occupation definition is an antitrust lawyer. And so if, let's say, two law firms in Chicago merged, we might think that antitrust lawyers living in Chicago are the people who are affected by the merger. But as you and I know, there are lots of different types of antitrust lawyers. They might specialize in different aspects of antitrust. They might have more seniority or less seniority, more experience or less experience. And it may be necessary to define the market even more narrowly. The economic test is the familiar hypothetical monopolist test, or we'd call it the hypothetical monopsonist test. But it would basically be, you'd look at whether a particular job that's being made available would be regarded as a substitute with other jobs. And all the jobs that are regarded as substitutes by workers would be in the same market. So in an actual antitrust case in the United States, the plaintiffs would almost certainly retain an economist or a group of economists who would have to conduct these surveys, gather data, both publicly available data and data from the firms, and use that to conduct these calculations to determine what the market is, and then what the firm's share of the labor market is. This is not very different from what happens on product market cases, where the plaintiffs tend to hire economists, and so do the defendants. But it is very difficult before you've hired the economist, before you've brought the case to determine whether some conduct, what a labor market might be. There's the publicly available information that one can use in the United States can be a starting point, but it's very, very crude. But the U.S. government does define what are called commuting areas, which are basically geographic areas in which people tend to cluster and work at similar jobs. These commuting zones or commuting areas are, they're defined and you can get them on the web, but they're probably much too big. They tend to be the size of entire cities, and people don't usually commute across a very big city. And similarly, the government has occupation definitions and numbers associated with them. They also are probably too broad. There might be a single occupation number for a pediatric doctor, a pediatrician, but they're different kinds of pediatricians. So there's some data that you can use as a starting point, but ultimately you'll need economists to conduct a more rigorous analysis.
I suppose the fact that these labor markets are local, geographically speaking, really makes the market definition from the supply side of labor quite relevant, because if you overstate the amount of alternative employers that might be outside of a collusive agreement, for example, and provide alternatives for employment for these workers, you might be understating the buying power of the companies engaging in that collusion, and so kind of weakening the claim by widening or shortening the market too much.
Yes, that's a problem. That is a problem, and it's a problem that's one has already seen in cases. So just to give you an example, in these fast food cases, you might have McDonald's might have, 50 restaurants in Chicago or 100, and they were accused of having a no-poach agreement, and that affected these workers who are pretty low skilled. These are people who work in the kitchen and at the counters. And one of the questions arose, well, how should the labor market be defined? And I think a lot of people had an instinct that it should be very broad, because if the wage at McDonald's goes down a little bit, then you can go work for Burger King, or you could work at a hotel or in a warehouse. But it's not clear that that's really true. It does seem to be the case that many people develop skills even in jobs that we classify as low skill, and not only that, but they develop relationships. They might choose where they live based on the commute to a particular work area. So it's quite possible that real world labor markets are very, very narrow. And a lot of more empirical work needs to be done before we fully understand what these labor markets really look like.
Thanks. One potentially final question for you. You've already introduced it in the overview of case law from the US. Has to do with how these issues should be addressed, or if and how these issues should be addressed within merger review, within merger control. You mentioned the two large cases, the Random House Penguin and Simon Schuster, the publishing house case, and the groceries cases. Of course, as far as I know, current merger control guidelines, at least in Europe, do not directly address, or at least in detail, this kind of issues. But as you mentioned in your book, once again, there does seem to be quite significant economic evidence that concentration or market consolidation has a negative impact on the overall level of wages within that sector or within that labor market. So wages tend to correlate negatively with HHI, and so I'm wondering how, going back to those two cases and to this scenario of how should merger control policy actually address these issues, what kind of analysis would it make sense for a competition enforcer involved in the review of a merger, especially a horizontal merger where firms will tend to need and look for similar workers with similar qualifications? How should this type of issues be addressed within the context of a merger control proceedings? And from the party's perspective, in cases that do end up showing significant concerns at this level, what kind of remedies would it make sense to design and offer to offset those concerns, if any?
Well, yeah, so that's a big question. But first I need to correct something that you said. So when I wrote my book, the merger guidelines that were in effect were called the 2011 merger guidelines, and they did not discuss labor markets. But when I was at the Justice Department revised the merger guidelines and issued a new set of merger guidelines in 2023. And the 2023 merger guidelines do have a section on labor markets. And so now the section, it's just a half a page or so, but it does provide a little bit of guidance, a little bit more guidance than we had before. But basically, the approach is very similar to the approach used for evaluating the product market impacts of mergers. And let me tell you a little bit about how this works. I also wanted to add that there are actually two more merger challenges that involved labor markets, although labor markets turned out not to be very central to their resolution. One was a proposed merger between Tapestry and Capri, which are two companies that make luxury goods, including handbags. And the FTC challenged this merger, and among its other arguments, it argued that the merger would lower. It argued both that the merger would raise prices in what it called the accessible luxury handbags market, and that the merger would cause harm to labor markets. Now, the agency was quite vague about how the merger might cause harm to labor markets, and ultimately the merger was blocked because of its product market effects, not because of its labor market effects. And then more recently, there was a merger challenge or a challenge to a merger between United Health, which is this gigantic health insurance company, and a company called Amedisys, which provided home health care services. And again, the agency argued that the merger would result in lower wages of home health care workers. So these are nurses, basically, who come to people's houses to provide health care. And it appears that merger is in the process of settling. So this is on the radar screen of the agencies, and in part because the merger guidelines tell them, whenever they evaluate a merger, whenever there's a proposed merger is brought to them, they should look at potential labor market effects of the merger as well as product market effects. Now, what does that mean as a practical matter? So there's this one initial complication, which is, as antitrust lawyers, when we think about a possible merger between two companies, the first thing we usually think about is whether these companies compete in the product market. So if you tell me that a grocery store and a hotel chain are merging, I might say, well, that's not going to have any impact on the product market because these companies produce completely different things. But it is possible that they compete for employees. And if similar types of workers look at these two companies for jobs, then there could be potential labor market impacts. And one place where this might arise is the labor market for software engineers. So when we think of software engineers, we usually think of tech companies like Alphabet and Meta and Amazon and so forth. And they all hire software engineers to code, to work on their software. But there are lots of other companies that hire software engineers, companies that, pharmaceutical companies that are trying to develop new drugs, automobile companies which are trying to incorporate computer technology in automobiles. Law firms might hire software engineers to help them with certain types of discovery software. So so you could imagine a situation where you have two companies that don't really do anything in common. One makes automobiles, the other invests in produces drugs, and they might draw from the same labor market. Similarly, you could imagine there are areas in the United States, and I'm sure Europe, where you have small towns or rural areas, and the major employers might operate, let's say, warehouses, data centers, fast food franchises, the city government. And these different employers, they might hire similar people who are maybe not college graduates, or people who don't have a lot of specialized skills, but are able to do maybe white collar work or other types of work in these various employers. And one has to be alert to the possibility that if two large local employers merge, there might be a lot of people who now don't have a choice among more than one or two employers. So that's one thing that agencies should watch out for. Another thing that agencies should think about are staffing agencies. So staffing agencies are companies that basically employ people, but then contract them out to other companies. So in the United States, a very common type of activity is for companies to hire what are called traveling nurses. So these are nurses who are willing to, move temporarily to another part of the country to work in a hospital which is currently understaffed. So the staffing agency hires these workers, and then when then it contracts with a hospital somewhere, and the worker is sent to that hospital. Staffing agencies are often just absolutely enormous companies employing tens of thousands or more workers. And they are frequently engaging in contracts and even merging with each other or with other companies. And they're not on the radar screen, I think, of most antitrust lawyers, but there's something to think about. Another problem that one has to watch out for, and I remember this when I was in the Justice Department, people scratching their heads over this problem. So, the Justice Department, when two large companies want to merge, they submit, various types of information to the Justice Department or the FTC, whichever agency has authority over their merger. And, typically, the traditional information they provided was all about product markets. And it was very fine-grained information, what products we sell, where we sell them, the prices we sell them at, who we think of as our major competitors, how much money we make, what our profits were last year, all that kinds of stuff. But we realized people realized when they were looking at mergers of, for example, manufacturers who own plants, factories in different parts of the country. They own 5 or 10 or 20 factories scattered around the country. It might not even be clear where those factories are located. And you might be able to find out on the web, but it wasn't part of the traditional information that these companies provided about the location of their factories. And then once you found out where the factories were, you needed to know something about the labor market. Who lived there? What did they do? What other employment opportunities did they have? And so that also turned out to be hard to find out. Even sitting in the government, who do you ask? Where do you get this information? So a lot of these problems relating to geographic dispersion had to be addressed. And then, there are just problems that are basically technical, but very complicated. An employer, employers employ lots of different types of people. They employ executives, they employ custodians who clean the floors, they employ secretaries, maybe people who work on an assembly line, software experts, maybe some medical personnel, bodyguards. They have so many different employees. Often they have only a few employees in a particular category, like IT workers. And so one has to think about very carefully, if a merger is going to occur, just how deep should we look at this at all these different categories of employees? If there's just two IT workers, should we be concerned if they might lose their job as a result of the work of a merger between companies that employ thousands of people? And that leads to the last point, which is this broader issue of balancing the impacts of mergers, because all mergers have multiple impacts, and particularly mergers involving very large firms. And we're already familiar with this. So if two grocery store chains merge, they might own grocery stores, hundreds or thousands of grocery stores scattered throughout the country. And when we do the product market analysis, of course, we pay attention to the local geographic impact of the merger. So if the two companies have stores that are not in the same local area, the merger is probably going to be fine. What often happens is, let's say they each have 1,000 stores and 400 of them are in the same area and compete against each other for customers, and the other 600 are elsewhere. And often merger regulators try to come to an agreement with the merging companies, under which the merging companies would divest some of their workplaces or retail outlets. So you face the same problem with labor markets, but once you start talking about labor markets, you also have to think about the labor market impact, the product market impact, and how we compare the labor market and the product market impact. Now, formally under U.S. law, a merger would be blocked if it has a negative impact on any market. In practice, the agencies aren't going to challenge a merger unless they think it causes substantial harm. And so if maybe 1 out of 100 markets is harmed, they may not challenge the merger. But once we're thinking about labor as well as consumer products, every merger now, the complexity is at least doubled, because you have to think about situations where a merger actually helps consumers but hurts workers, or helps workers but hurts consumers. And those are just issues that have to be addressed at the enforcement stage. Now, you asked about remedies. The usual remedy in merger enforcement is simply to block the merger. Sometimes, during the Biden administration, the agencies were pretty strict about this. They didn't want to enter a settlement. I think under the Trump administration, we've already seen that settlements are going to be more common, just as agencies do on the product market side. One possible remedy would be for the merging companies to divest certain workplaces, and that was discussed in connection with the Kroger-Albertsons merger. So it was a possibility that the merger could go through, and both Kroger and Albertsons would sell some of their grocery stores to a third party in order to preserve both product market and labor market competition. Other remedies are possible, but really, I think the agencies tend to be comfortable with divestitures, but not anything, that's more intrusive or complicated than that.
And that's a very interesting point, because it's actually about how to generate an alternative employer through divestment, rather than how to generate an alternative producer through the same way. So it's a very interesting.
Now, in the Kroger-Albertsons case, there was this company that had experience. I think it mainly had experience as a wholesale grocer. So, they knew about groceries, but they didn't sell directly to consumers so much as to grocery stores. And I think they did operate some grocery stores directly, but we're not very successful at it. So this is just one of these hard, questions. It was possible that if that some number of grocery stores had been sold off to this company, that competition in both the product market and the labor market would be maintained. But people were worried that actually what this company would do is, tread water for a little while and then eventually sell off those grocery stores or close them down or something. So this is a typical, complexity that one has to address in merger enforcement.
Yeah. Professor, thank you so much. I've been taking notes throughout our conversation. Incredibly interesting and helpful. Thank you so much for your time. I've learned a lot. I think this topic will continue to evolve, and hopefully with not too much additional complexity for us practitioners. But there we are. Thank you so much, and it's been a pleasure to have you on.
Thank you. I enjoyed talking.
Join us again soon for the next episode of Thinking Competition.